Hello, my name is Kaidrin or Mia, and today I will be explaining the relevant laws of the Vienna Convention of the Law Treaties or the VCLT and how it applies to the legality of state Aramika's suspension and state Bothuna's defenses. I will also be analyzing whether environmental obligations evolve into jus cogens norms, which will override treaty provisions, followed by the interactions between competing principles such as pacta sunt servanda, material breach, and jus cogens in this scenario. All right, so I'll first begin our discussion by explaining the relevant principles that could be used in our scenario. So, beginning with what even is a treaty? A definition of a treaty can be split between two parts. The first being an international agreement between two subjects of international law, and three who have the intent to create rights and obligations under international law. It is already said by Schwarzenberger. It is basically a consensual agreement that is agreed between two parties who want to agree on something, who want to agree on a piece of rule or whatsoever in the international landscape. So when we're talking about treaties in general, we cannot forget the Vienna Convention on the Law of Treaties of 1969, also known as the VCLT in short. So the VCLT is essentially the go-to or the governing legislation when it comes to talking about treaties at all. So the VCLT considers the roles of treaties as a vital history of international relations. It recognizes the importance of treaties as a source of fundamental law for creating peaceful cooperations between our nations. So conventions, declarations, covenants, you name it, are together known as treaties. So, when a treaty comes into force, or when it is actually performed realistically in our international landscape, it comes with its effects and its repercussions. The first being treaties are actually treated like contracts, according to Article 26 of the VCLT. So treaties are actually created from direct negotiations between legal counterparts where they are bound by the terms of the agreement. This is also known as the legal principle of pacta sunt servanda, which represents the inviolability of treaties. This means that the treaties must be performed and must be respected, just like any other normal contract in civil law. The second is the retroactivity of treaties according to Article 28. This means that unless a different intention appears in the treaty or when it's later established, any action won't bind a party that has not existed before the date of the treaty. So whatever that is assigned to them before a treaty has come into force won't apply. It will only apply after the treaty has come into force. So when we're talking about how far the treaty is applicable, we refer to Article 29, which is the territorial scope of treaties. This means that unless a different intention appears at the treaty or that is otherwise established, a treaty will be binding on each party in respect of its entire territory, which has been agreed by the nations. And an application of treaties relating to the same subject matter according to Article 30. It is a treaty if a treaty specifies a subject or its compatibility, whether before or after, the provision of the older treaty will prevail. So the provisions of an earlier treaty, which is not compatible with an older treaty, will also apply. So now that we explain what the potential effects of a treaty that has come to force are, let us go into how our treaties even formed in the first place. But we have to remember the first thing is that no nation can be pressured or forced into a treaty. That means a treaty is voluntary and no state can be forced or bound by a treaty without consent to be bound by methods that are recognized in international law. So when we are explaining how treaties are formed, we can explain it in five parts. The first being formality and the second being consent. So when we are showing a formality, a signature can often be used to signify your formality, just like any other signature that is found in a civil contract. The second is consent. So that means consent to be bound by a treaty can be easily expressed by a signature or an exchange of instruments. So what do we mean by the exchange of instruments? Comes part three, which is your methods to show your consent. It is either a ratification, an acceptance, an approval, or an accession. So for acceptance and approval, it's pretty self-explanatory. It means you agree to be bound by a treaty or whatsoever. But countries may want to think this through. So that can be expressed via a ratification. What this means is that it can be in a form of an international internal act of approval, such as the opportunity to re-examine the effects of a treaty or give a little bit of breathing room for public opinion, or an internal procedure, which is the exchange of instruments between the parties, which are often signed by a head of state, a head of government, or a foreign minister. It is these three people to show your consent or intention. The second is an accession. What it is that when a state becomes a party of a treaty for whatever the reason, and they won't be able to sign the treaty, only if the deadline for signature has lapsed, this option will be provided in the treaty. So again, it gives a little bit of a breathing room, and once the signature timeline has lapsed, the treaty will automatically enter into force. All right, so when a treaty enters into force comes part four. This means that when a treaty will enter into force, it will be dependent on the date provided and negotiated by the states on when it will come into force. So if there's no date, a treaty will enter into force automatically as soon as consent to be bound is established by parties. So as soon as your actions to show consent is shown, um, it will be entered into force. And the fifth is a registration and a publication. This means that when a treaty enters into force, it will be transmitted by the Secretariat of the UN. So every treaty or international agreement will come into force as soon as possible and will be published. So as soon as the discussions are done, enters into force, it will be published. So when we're explaining the topic of treaties, we can't fail to mention customs. So what essentially customs are is they're actually actions or of international law that has evolved based on practice or the customs of states. So customs are actually ideally suited for the development of the general principles of law. So it can fill in the gaps in the law to keep up with our ever evolving situations on international scales. So, for example, when a treaty when it when a pre-existing treaty is already there, but there have been evolved practice. We have to consider the practice of the states to deal with that particular situation in order to move forward. So when a custom or a norm is accepted and recognized by the international community as a whole, but its fundamental principles or whatever happens to contradict what an existing treaty has said, it will be henceforth known as a jus cogens, according to Article 53. So now that we've and explained the relevant principles and how a treaty is even created, we can now address the issue between State Arabica and State Butuna and assess the legality of State Arabica's suspension of the treaty. So State Arabica will aim to invoke Article 60 of the VCLT to prove that State Butuna actually breached the the provisions of the treaty. So the termination or suspension of the operation of a treaty can only be done as a consequence of a breach. And State Arabica will also claim that the state Butuna failed to adhere to the environmental safeguards in the treaty obligation itself. So for State Butuna to defend their position, they will try to invoke Article 64 of the VCLT. It is where a new peremptory norm of a general international law that has emerged, where if it contradicts and is in conflict with any other existing treaty or practice, it will render the existing treaty void and the jus cogens will take precedence. So the court will have to determine whether the issue is fundamental enough to qualify as a jus cogens. And the rules of the jus cogens must be so important that it takes almost unanimous agreement which will also translates to a high threshold in consideration for the courts. And it also include a very heavy opinio juris before the existing treaty is replaced. And opinio juris basically means you need heavy evidence to back up the how fundamental the issue is. And you can be demonstrated by real life examples, such as the Nicaragua and the USA case, where the court's judgment regarding the use of armed force in international relations, and also the case concerning East Timor or the Portugal and Australia case on the rights to self-determination. With this in mind, in my opinion, I think it is likely for State Butuna to be successful to argue the existence of the jus cogens because the General Assembly has already recognized the right to clean water as a norm, and with the Assembly as a whole already recognizing it I think we can safely assume that the norm is already fundamental enough for the courts to agree where the existing treaty will be considered void. All right, now that we've already addressed the issue between state Aramaka and state Futuna, what can this tell us about the attitude of the courts in regards to whether the court's attitude with Pacta San Savanda and Jus Cogens? So, with the high thresholds of the courts in considering what fundamental circumstances are, it can tell us that the courts actually hold the principle of Pacta San Savanda to quite a high regard. That is because the courts are very reluctant and they don't want to create any unnecessary norms that is influenced by political or or a state's selfish gain. It is also to ensure the stability of the law and reducing confusion in the law. So the courts are very restrictive on that because they want the law to progress well and also be controlled. But that is not to say that there's a total prioritization of Pacta San Savanda either. That's because the courts also considered Juice Coggins because they want to keep up with the ever-evolving situations that is presented to us internationally, which an existing treaty cannot do. So the courts want to accommodate future situations because law can't be stuck in the past. It has to evolve like any other law should. So when we're explaining the topic of treaties, we can't fail to mention customs. So what essentially customs are is they're actually actions or of international law that has evolved based on practice or the customs of states. So customs are actually ideally suited for the development of the general principles of law. So it can fill in the gaps in the law to keep up with our ever evolving situations on international scales. So, for example, when a treaty when it when a pre-existing treaty is already there, but there have been evolved practice, we have to consider the practice of the states to deal with that particular situation in order to move forward. So when a custom or a norm is accepted and recognized by the international community as a whole, but its fundamental principles or whatsoever happens to contradict what an existing treaty has said, it will be henceforth known as a jus cogens, according to Article 53. So, in my 15-minute segment, I have explained the elements of a treaty, how a treaty is formed, the addressing of the issue between state Aramaica and state Butuna, my opinions on how the courts balance the interest of Pacta San Savanda and Jus Cogens, and also my personal opinions and recommendations on how we can move forward with peremptory norm and Jus Cogens. With this in mind, I hope it is useful and thank you for listening.